Hello, I'm Gary DeWitt with the DeWitt Law Firm, and today we're talking about if you should have a power of attorney. As you can see, powers of attorney are 20% or less of the cost of the alternative. There are many other non-financial costs of guardianship, which we'll cover in a few minutes. A guardianship starts at $3,000 plus fees and cost for an uncontested guardianship. If somebody contests the guardianship or complications develop, the cost goes up rapidly. It wouldn't be unusual for a complicated guardianship to cost $5,000 or more. Then there's the cost of the annual reports, accountings, and inventories that the court will want. Even for a simple estate, this can add another $750 and up a year. Not to mention, if these reports are not filed in time, the judge will send you a nasty letter asking where the report is. Also, you have the cost of defending against guardianships. It can cost you, out of your pocket, the same amount of money to defend against somebody seeking a guardianship over you. Joe's son got a doctor to sign a note saying that Joe was incompetent. When I met with Joe, it was obvious that he was completely capable of managing his own affairs. In order to defend against the guardianship, we had to have Joe go through a 4-hour exam from a psychologist and then file the report with the court. That exam alone was $1,500. Not to mention the time and embarrassment of having your name in the public record as incompetent. Finally, the outcome was that the other side withdrew their claim and Joe was free to make his own choices. But if Joe had had a durable power of attorney, then all he would have needed to do is cancel it and the matter would have been handled. Everybody over 18 needs a comprehensive set of power of attorney documents. These documents form the cornerstone of your estate plan. They are more important than any trust or will you can create when it comes to protecting yourself. My daughter worked at a summer camp in Oklahoma while she was trying to get enrolled in college. The camp was down in the valley and didn't have cell phone service, so we just couldn't call or text her. Enrolling in college is a paperwork-intensive process, so we were able to use the power of attorney she had signed to us to sign and return the paperwork to the university. Without that durable power of attorney, she might not have gotten enrolled for the fall semester. If you have a child or a spouse going off to boot camp, then they should absolutely have a durable power of attorney. Somebody here needs to be able to handle their local business while they're away. A comprehensive power of attorney package will empower someone else to speak for you when you can. If you're injured, suffer a major medical incident, or develop dementia, a power of attorney tells the world who you want to speak for you. Without it, nobody is legally allowed to make decisions on your behalf. A judge must appoint somebody to speak for you. It protects you and your finances. Without a durable power of attorney, you don't know who will be appointed to watch over you and your finances. It avoids costly guardianship proceedings. We spoke just a minute ago about the cost of guardianship. In a few slides, I'll go over a few more details. It saves money and protects your estate because you've planned in advance. If you don't have durable powers of attorney, then your family is forced to court. It ensures your wishes are carried out quickly without the need for a judge to intervene and interfere with every decision. Finally, it protects you, your family, and your future. A guardianship is a court process to determine who will oversee making decisions for you. The judge weighs the evidence available and decides who will be in charge and how much power they have. Guardianships are a public court proceeding. All your personal and financial information will be published in the public record. In most cases, the person they're talking about can't talk for themselves. Because of this, the judge doesn't get to hear who you would want in charge. The judge must decide based on outward appearances only. The judge isn't usually aware of internal family dynamics and issues. The judge doesn't know your daughter is married to a raging alcoholic who likes to spend money like it was water, unless it's brought up. The judge doesn't know that your son has a history of mental disease, unless it's brought up. The judge doesn't know you have a daughter who sneaks in and takes your pain pills, unless it's brought up. And there's many more things just like this. If you want a voice in who will care for you, how much power they have, and keep a judge out of your and your family's business, you need a durable power of attorney. A power of attorney is a legal document that gives someone of your choice, called an attorney-in-fact or an agent, the authority to take action or make decisions on your behalf if you should be unable to do so for yourself. There are two types of powers of attorney: the power of attorney for financial matters and the powers of attorney for health care. A financial power of attorney lets someone you name take actions or make decisions on your behalf if you're unable or unavailable to do so. They can do things like pay your bills, deposit and cash checks, handle real estate transactions, and take care of other business decisions and actions. The healthcare power of attorney lets someone you name take actions or make healthcare decisions on your behalf if you can't. Those decisions are things like obtain your healthcare records, communicate and talk to the doctors, pharmacists, and other healthcare workers, manage your personal care, residential placement, and medical treatment. There's a lot of misconceptions around powers of attorney, and I'd like to go through a few of them now. First misconception is powers of attorney are one and done. I'll never have to have new ones. The truth? Powers of attorney are documents that should be updated when family dynamics, financial goals, or the laws change. You may find out too late that your power of attorney is no longer valid. Further, some financial institutions may not accept a stale power of attorney for fear of a lawsuit. Another misconception is, I can create my own power of attorney online. I don't need an attorney. The truth is, powers of attorney are not one size fits all. Each person's situation is unique. If you use cookie-cutter programs, it may not cover specific situations. Specific language may be required to grant proper authority in certain transactions. Here's another one. I shouldn't make my power of attorney active until I become incompetent. While the timing of granting agency through a power of attorney is a matter of personal preference, an immediately effective power of attorney should be considered. A springing power of attorney usually requires a finding of incompetency by at least one doctor and sometimes two. This can cause delay, and there may be situations where a doctor will not sign off that you are incompetent. Making your power of attorney effective immediately removes the need for a doctor to declare you incompetent. A common misconception is that my spouse automatically has a power of attorney for me. The truth is, your spouse does not automatically have a power of attorney for you to make decisions and sign your documents if you can't. I don't need a power of attorney. I'm young and healthy, and I don't have many assets. But every person over 18 should have a power of attorney. You never know when something catastrophic may happen. You need to have a plan in place to take care of you in such an event. If you don't have a power of attorney in place beforehand, you have no control over who will be making decisions on your behalf. What happens if I don't have a power of attorney? You will have no control and lose control over who makes decisions on your behalf. A judge may have to appoint someone to handle your personal and financial affairs. A guardianship is a court proceeding, and all your financial information will be made public record. A guardianship is an expensive process, costing thousands of dollars. Guardianship can last for years, or until your death if you don't regain capacity. A guardianship is expensive and time-consuming for your loved ones to go through. Power of attorney documents are absolutely essential documents that everyone should have. The experienced attorneys at DeWitt Law Firm will create power of attorney documents specifically for you and your unique situation. To get started, go to DeWittLawAR.com or call us at 479-717-6300.